Okay, well, hey, I jumped around there. Excuse me. Still getting this set up. Sorry, everyone. I'm just trying out a live stream because I wanted to talk about this TechDirt article here that you can see over here, over my shoulder. Because, as I found out when we just did the live stream, Hangouts is going away, so I'm going to start having to do live streams a different way. So I'm just trying this out to see if this is a good way of doing it. I'm using OBS, and from what I can tell, everything should be set up properly, and I should have, I should be able to see the chat and have the, oh, where is it? Okay, I don't know where the chat is right now, but I should be able to have the super chat up. And working, so we'll see how well this works, and because I can't really see what the output is right now, so I can't see what you're seeing. I'm just seeing it on my own thing, so we'll see. But please feel free to leave a chat. If you leave a super chat, it should just show up right here on the screen with us, so hopefully that will work. But let's talk about this. Section 230 is not exceptional, not unique, not a gift. It's the codification of common law liability principles, and this is the very point I've been making for months. Really, since this started being a controversy, we keep hearing about how, oh, well, you know, Section 230 shouldn't apply to, you know, Facebook or YouTube because now they're publishers and not providers, and Section 230 doesn't make any distinctions about it. So, TechDirt is actually done. I mostly like TechDirt. Yeah, there are some things like net neutrality that they kind of drank the Kool-Aid on, but they're mostly good, and I really like how they leave links to everything like this study from the Mercatus Center that we'll go into. I'm not going to look at the study itself. I read the study, but I think the TechDirt article kind of, you know, hit the major points of it, and like I said, this is the stuff I've been talking about now for months. So, we'll check it out. They say there are so many myths about Section 230 that seem to need debunking. There's the myth that it requires platforms to be neutral, and they link to a previous story they did. Also, the myth that if you moderate too much, you lose your status as a platform, and that it's a gift to big tech. And I've responded to all of these. None of them are true, as Mike Masnick points out. So the idea here is, along with the claims that 230 is a gift to tech companies, is the unfortunate similar myth that 230 is somehow exceptional, or that it treats internet companies different from any other company. This has never been true. Instead, it's really about properly applying liability to the party actually violating the law, rather than putting the blame on the tools and services they use to violate the law. Brent Skorup and Jennifer Huddleston of the Mercatus Center have now put out an interesting paper highlighting how, far from being a unique gift to internet companies, Section 230 was merely the codification of basic common law principles regarding liability. And so, as I've mentioned before, you know, one of the issues is that this was passed along with the CDA, the Communications Decency Act. And the problem with that was it was very censorious about things that you couldn't say online if it was, you know, offensive or whatever. And basically none of that survived the courts, but Section 230 did, because they put Section 230 in there because, you know, even if it was illegal to, you know, post something offensive or whatever, the website that you posted it on or whatever couldn't have any liability for that. So let me just scroll down a bit. So for decades preceding 230, the general common law principles had converged on the concept of conduit liability, which is more or less what we see in Section 230. You don't blame the conduit for merely passing along the message. So the conduit would be the website or the social media company, or, you know, your ISP or whoever. You know, none of these are responsible for the things that you post, even if they decide that, oh, well, we'll moderate this, we'll take out the things that are offensive, or we'll take out things. You're still not liable for what someone else does. So here they're quoting from the study. As shown above, even before the creation of Section 230, many courts had shifted from strict liability towards conduit liability protections and fault-based requirements. In many circumstances, liability would not have attached even if the distributor had known of the tortious material, because the social and judicial norms favoring practical moderation practices and free speech had eroded the traditional liability standards. Section 230, in effect, codified the conduit liability protection that was being applied to traditional media distributors and was sometimes applied even after 1996. So, this is Section 230 is nothing special. It's just, what the way it's always been, and they had put it in there to preserve that because, they were, like I said, they were trying to censor things that were too, sexy or whatever it was in the Communications Decency Act. And so they mentioned Lunny v. Prodigy. And so this was Prodigy used to be like this really big provider of internet services. You'd go there. Even like before the internet, they were like their own service that you dial up to directly, kind of like CompuServe or whatever. And you can have access to news and weather and shopping and all sorts of stuff. Not all the stuff you can do online. You didn't have stuff like online video or JPEGs took 20 minutes to download in those days. But this was a case where it was a Boy Scout troop. I don't remember if Lunny was the scoutmaster or if he was one of the Boy Scouts or whatever. But there was something like someone had posted. I guess today we would call it a meme, but it was kind of something not very flattering to Lunny and his scout troop, and so they sued. And so they say, an internet service provider and bulletin board operator, they're talking about Prodigy there, the court held, like a telephone operator, is merely a conduit. It made no difference to the court, and the conduit designation was still applied, even when the bulletin board operator reserves for itself broad editorial discretion. So, Connor Winkler is asking, are they kind of like Pacific Bell? Well, it's really hard to describe unless you were actually alive during those things. Before the internet, you had a bunch of services, like CompuServe was one. I was on Genie for a while, and then I was another one that was on Portal. And you could dial into that surface. You actually had a modem on your computer that would dial in over the phone line and connect you at 1200 baud, or ended up being as fast as 56 kilobits a second, so it was really slow. But that was how you got online, and you could go into Usenet discussions. You could trade pictures with people or whatever, go into chat rooms and get news and weather and things like that. So it's not like an ISP like Pacific Bell. It's really more. I guess Facebook would probably be the closest, the most analogous service to what we have today, because you can kind of go there and you could go into discussion groups with people and look at news and whatever. So it's probably more like Facebook. And this was big for a long time. And if a lot of these people had been there back then, they would have been going on, oh, Prodigy is this huge monopoly and no one will ever be able to topple them. And so we need government to step in. And of course, who's heard of Prodigy nowadays? But, I guess if you remember AOL, that was a lot like how Prodigy was. So, all right, let's see. Moving on to this next part. Without that, many of these cases, even though they would ultimately be unsuccessful if the court were able to decide, would be prohibitively expensive for internet platforms, creating, in effect, a censorship by lawsuit system. And we see this in all sorts of things. For those of you in other countries, in the United States, we do not have loser pays. So there's really nothing stopping someone for suing someone for whatever reason. We've seen things like that. Oh, if you don't knuckle down and do what we want, we'll bring a lawsuit. I guess you're like, well, you don't have any chance of prevailing in the lawsuit. It's like, no, but we'll bankrupt you doing it. And they actually give some numbers here. A report by Engine estimated that without Section 230, the costs of litigation might be prohibitive for many startups, even if they might win the case. according to the in-house and external attorneys consulted for the report, having to respond to a user-generated content liability claim through a motion to dismiss. And that's just very preliminary. And the motion to dismiss is where you just go into the court and say, look, they've got nothing. They have no chance of prevailing. Let's just end it right now. Just going through the motion to dismiss could cost $15,000 to $80,000. And having to take such a case through discovery could cost a firm $100,000 to more than $500,000. And that's where you're not even getting up to the trial. That's just through the discovery phase. And this is a big problem in our tort system because you can really threaten to bankrupt someone doing that. Yeah, Connor's posting another couple of things about Pacific Bell was called a monopoly and was broken up. Yeah, the big monopoly, I've talked about this before, it used to be AT&T. And so government broke it up. They broke it up into the baby bells like Pacific Bell. Here it was Bell South, and there was Bell Atlantic and some others. So you still had like your local monopoly for that. But long distance service was pretty much deregulated, and you could choose your own long distance provider. And it's like Connor said, people are complaining about, oh, it's going to be too complicated. There's too many choices. And all the quality is going to be terrible, and you're not going to be able to understand everyone. And of course, it's going to be so expensive. These corporations are going to gouge their prices, everything. Of course, it was exactly the opposite. Long distance got cheaper and cheaper and clearer. I remember all those ads for like one was 1010 220 or something like that. Services where you can actually call long distance for 10 cents a minute. Now, of course, I don't know if we even still have long distance because I don't have a landline. But I mean, if you got a cell phone plan, most of them, you can pretty much call anywhere in the U.S. and Canada for basically free. It's just part of your normal plan. So a lot of you may be going, what's long distance? Used to be if you dialed outside of your area code, you were charged extra for long distance. So, it just made things so much better, breaking up AT&T and doing that. So, yeah, I mean, that's what they always say, and it never ends up being true. So the study also says a period of uncertainty and massive collateral censorship would have ensued because online providers do not know in advance where their users are located. Any provider with users in New York would have been potentially subject to liability for users' posts under the Stratton Oakmont decision. Section 230 precluded that turn of events. In Stratton Oakmont, they were like some kind of brokerage firm or something. They were engaging in all this stock fraud and things like that. It was a huge case. It was all over the news. Well, I think this was Prodigy again. Prodigy, you go on and get the news, and people were covering it and talking about it. And Stratton Oakmont, they're doing all these terrible things. And so Stratton Oakmont tried suing Prodigy for libel. Even though Prodigy was just the word they keep using as the conduit. So, this is why Section 230 is so important. And what they're saying here is Stratton Oakmont was being prosecuted for violations of New York law. So if it's a user in New York, if they're suing in the state of New York, then that would be them violating the law. But what if you, as the service provider, aren't in New York? What if you're in California or Texas or somewhere? But you have a user in New York who's posting something that violates New York law. Why should you be responsible for that? I was talking about this before a couple of weeks ago on the podcast, I think it was. There was some case, I think, in Sweden where someone had posted quote-unquote hate speech in a Facebook group. And the Facebook group was run by a Swede, so they were running him into court. Even though it wasn't him that was posting it, it was just people posting it to his Facebook group. And the people posting in the Facebook group, they didn't even try to claim were Swedish. So it might have been perfectly legal to post it where they were standing up. I still remember party lines. Oh, yeah, those were fun. You pick up your phone and you hear someone else's conversation. All right. So let's see. Going down. All right, so the idea that Section 230 is somehow exceptional or provides some rare gift that would not otherwise exist is not supported by the history laid out in this paper. Conduct liability, very much the consensus view among courts, thereby making it I think I messed up. I'm trying to edit the sentence and I think I messed up the grammar. Content liability was very much the consensus view among courts, thereby making it the accepted common law even prior to 230. Killing Section 230 will harm competition against the big internet companies at a time when we clearly need more competition. And they go into that. And so Connor again says, shouldn't censorship be something TV networks, Cartoon Network, Disney have control over rather than the service provider? Well, we shouldn't have any censorship in the sense of the government saying, or you must do this and you're not allowed to show that, and etc. But, I mean, they should be perfectly free to say, hey, we don't want to show this TV show, or we don't want to show this commercial, or, Netflix says, hey, a lot of people are, complaining about this show or this movie that we're showing, so we're not going to have it on our service anymore. You could... You can still you still have a party line? Well, I can't imagine like a party line still existing without people like completely losing their tops over a privacy violation. Anyway, the study says, going from a blanket to a tailored shield, however well intended, must account for the chilling effect it will have on innovation by startups and small firms, and for the artificial barrier to entry in the market that will grant additional protection to incumbent firms. So, I've talked about this before as well. Like YouTube was started by 3 guys in a garage. If you keep putting all of these problems in there, then they won't be able to do that for, much longer, because to even just get going, you'd have to have these, enormous legal teams to try and deal with all these lawsuits that are going to come your way. So, if you want YouTube and Facebook and Twitter to have competition, then you want to preserve Section 230 so that they'll be able to do this without a whole bunch of startup costs. And so they say the Section 230 reform movement is growing, and many of the reform arguments complain that online intermediaries receive a special dispensation regarding publisher liability. The truth is more complicated. Courts gradually chipped away the regime of strict liability for publishers and content distributors owing to the practical difficulties of screening all tortious content and to the potential for restricting First Amendment rights. Those courts found that mass media distributors warranted extensive liability protections, including an important protection for conduit liability. Congress solved the dissonance by enacting a law that affirmed the precedent and its rationales, the impracticality of holding online content distributors liable, and the potential violators of freedom of speech that would ensue from strict liability. Section 230 established a regime of liability protection for online content distributors just when it was needed, at the time when internet firms had started to reach audiences of tens of millions, and still provides liability protection for large and small distributors alike. For all the foregoing reasons, we have argued that Section 230 is good policy, and I think I'm at the end of the article there. So, there it is, exactly what I've been saying. So check out the entire study. Is actually a pretty good read. Like I said, the TechDirt article hits the main points and does pretty good. There wasn't really anything in the article I felt I had to, read out extra like I do sometimes. But yeah, this is what Section 230 is about. If you want to start up your own competitor to Facebook, you need Section 230, because otherwise the first thing you post that someone takes offense to, they're going to try to drag you into court. Section 230 cuts that off, because like I said earlier, even without Section 230, even if they wouldn't have prevailed in court, because it would have been clearly within your First Amendment rights to post that, and they wouldn't have any liability at all, it could still cost tens of thousands of dollars just for you to get to the point where you can go into court and say this should be thrown out. So this is why Section 230 exists, and this is why it's good. So let me know if you like this format. This is very preliminary here. Really just trying to test it out and see how well it works. Because I'm going to have to do something now that Hangouts is going away for the main live streams. I got to figure out how to get other people in here, the supporters and the co-hosts. I usually invite them in. We'll probably do it over Discord, do a voice channel or something like that, but we'll have to see how that works out. So yeah, and I'll be interested to actually go over to YouTube to see how this video came through, because it looks great on my screen, but how much did it get chopped up and everything on the way to you? So please, please, please let me know what you think in the comments if you have any idea for how things can be improved. I'm using OBS Studio. If you know of any better software to use or any good plugins, that I could use to get other people in on the chat instead of going through Discord or whatever. Any ideas like that, please let me know. And thank you for watching. Again, let's really all get behind Section 230 and stop this narrative about how we need to end Section 230 or make exceptions, because now there are publishers, not providers, and things like that, and that means that government can come in and censor them, or government can force them to allow conservatives or whoever to make posts or other things that they don't agree with. Artemis Alina, the downside to live streams is that people can't always be around when they're on. Yeah, I was just doing this one here just as a test and kind of replacing, what I would normally do, a pre-recorded video and post it Tuesday at 10 a.m. around this time. This is kind of the replacement for that. Connor says, occasionally your camera stutters, but the voice quality is good. Okay, I can probably look at the camera settings and get that going a little better. So thank you all for watching. Thank you for supporting this channel. Remember, you can always go to donate.bogosity.tv and see all of the ways to support. You can also go and see me over at bittubers.com. I'm Shane DK there. Thank you all for watching, and until next time, stay strong and be free.